Welcome to Clause 8, The Voice of IP, hosted by Eli Mazur. How is patent policy made in Congress? Few know better than Phil Warrick. Phil served as Senator Coons' top IP advisor after Coons helped restart the Senate's IP subcommittee. In that role, Phil helped lead the subcommittee's efforts to improve America's patent system, including legislation to fix the patent eligibility mess. Those efforts were a dramatic departure from Congress's previous fixation on the patent troll narrative. After Coons' friend and fellow Delaware native, Joe Biden, was elected as president, the Innovation Committee was hopeful that Coons would use his top role on the subcommittee to prioritize patent issues within the Biden administration and Congress. However, Democratic Senator Leahy had other ideas and took over as the top Democrat on the subcommittee. Since that time, the subcommittee has moved in a very different direction, a very anti-patent direction. And Leahy's views have won out in seemingly every major administration decision related to patents. Yet, in another twist, Leahy has announced that he is retiring and won't seek re-election in 2022. So Coons is likely to return to his role as the top Democrat on the IP subcommittee. On this episode, Eli talks to Phil about what it is like to work for Senator Coons, how to effectively lobby on patent issues, and big tech's influence on patent policy. Clause 8 is part of IP Watchdog and sponsored by Harity, the go-to firm for Patent 300 for patent preparation and prosecution.
First question that I like to start with is, do you remember when you first learned about patents and what was your impression about the role?
Oh, great question. So I do remember this. I was a college student in Akron, Ohio, and I was studying computer science and philosophy and hadn't really decided exactly what I was going to do with myself career-wise, but I had this notion that I wanted to be an attorney. And I think it's just because I like to argue with people when I was a teenager. But someone told me, hey, you should meet this guy. His name's Roger Emerson in Ohio, and he does patent law. And I didn't know what a patent was. But they said it would be great. It's technology, it's the law. And long story short, I ended up working for him. He had a little IP boutique there in Ohio. And it was great. I learned so much before I ever went to law school. I spent a couple years. His firm merged with another firm, and eventually he went back to another firm of his own. But he and the other attorneys there were so generous with their time and with explaining things to me. They encouraged me to take the patent bar before I went to law school, which I did, which I suppose is great, although that was almost 20 years ago, and I've never prosecuted a single patent application. But in any event, that's how it all started.
Well, that's pretty cool. I have any thoughts about the role they played at the time? Is it something just you thought of as a career, or did you think patents are things people put on the wall?
Yeah, I mean, I was immediately intrigued because to me it was, all the things I wanted to do, particularly the litigation side. So this boutique didn't do a lot of litigation, but I did see there was a case where they had a client who was, the quintessential garage inventor, and he had this idea and had shopped it around to some companies, and everyone said thanks, but no thanks. And lo and behold, he started seeing his product on the market, and it all worked out. And he got paid for his contributions, but it made an impression on me that this really is something that can give you a seat at the table as the small guy. It's very entrepreneurial, very America. I loved it. And just in terms of a career focus, I from that point on, there was no question that I wanted to do IP.
Yeah, no, that's a cool story. So you went on to law school. You did a patent litigation at a few big firms, clerked at the Federal Circuit, worked as associate solicitor at USPTO, which I've heard you refer as the best job in IP. And then you became counsel detailee for Senator Coons. Tell us a little bit about the process. How did you become a counsel detailee? Did he come there and handpick you? Did you have to apply? What was that like?
Yeah, so it wasn't the former, although that would have been amazing if you had just personally visited and lined us up. Like, I'll take him. Uh, no, so the process wasn't overly formalized as far as I could tell. But what's interesting, I had no idea before I was a federal employee that there's this regular habit of loaning folks within an agency, between agencies, and obviously even between branches of government. And it's a great opportunity. It gives folks exposure. I think it's good for the groups loaning people out. It's obviously great for the people like me who get to do it. I had the good fortune of being friends with Jamie Simpson, who is the former detailee from the PTO to Senator Coons. We clerked at the same time at the federal circuit many years ago now, and she told me a lot about her experience, and it sounded so intriguing. I thought it was worth a try. Honestly, I never had any intention of working on the Hill or anything related to Congress. So it was a little bit of a shock to me. It was certainly a shock to my wife, who didn't see that curveball coming. But then I put my name in the hat. There have been several detailees who have gone from the PTO, some from solicitor's office, some from other parts of the agency. And fortunately, it all worked out, and it was a tremendous experience.
And you do see different detailees going to work for different senators or even congressmen with different views on patent issues. Is it that different people gravitate to the members of Congress whose views align, or is it at that point, I'll go work for whatever senator and kind of give him my best advice? How does that kind of work?
Sure. So there are only so many of these opportunities. So there's a certain amount of, if this is something you want to do, I think as a PTO employee, I think a lot of folks would jump on the opportunity wherever it may be. I didn't realize how fortunate I was going to be to work with Senator Coons. Frankly, I didn't know that much about him when I got there. I'm sorry to admit. Hopefully, he doesn't listen to this, but I have so much respect for Senator Coons. Having worked with him for 2.5 years, I think we had we shared a lot of views about just our perspective on intellectual property, but also he's just such a thoughtful guy. He really cares about IP, which, with all the issues on the Hill, to dedicate a significant amount of bandwidth to an issue like IP is really impressive and fortunate for me. But that said, I think there are so many offices where I could have had a great experience. And I'm an attorney, and most of us who have done this are attorneys, and it's a client, and I think I could have done the job and gotten as much out of it, and hopefully been as effective working for someone who maybe had a different perspective or had different constituents with different concerns.
Talk us about that transition. You've spent your career doing litigation and appellate work up to that point, and then here you are kind of go work for Capitol Hill. What was that transition like? How did you kind of learn about what should I be doing on whatever day of the week once you got there?
Oh, wow. It was such a whirlwind. And some folks tried to prepare me. I have another former co-clerk, John Lee, had been on the Hill as a detailee, and he's there again right now on the House side. In the solicitor's office, I worked with Joe Mattal, who spent a long time on the Hill. And they did a great job of trying to, and Jamie, of course, who had my role before. Nonetheless, I got there, and it's just so different. It's overwhelmingly different. Everything moves at such a fast pace. And the thing that's maybe the most challenging is that in litigation, you really know the rules of the road. You know who your adversary is. There always is one. You've got rules. You have someone who makes a decision. You generally have some timelines. And that's not how the sausage is made on the Hill. You throw all that out the window, and you've got voices coming from everywhere, and it's very interesting. And then so much of it happens at such a high level. So I had tried to prepare myself where I thought, okay, I'm not writing briefs, I'm not writing legal memos per se. And the first thing I wrote for the senator, I gave to the chief counsel, who was Erica Songer at the time, and I thought I had just I don't want to say dumbed it down, but tried to generalize and make it as high level and easily digestible as possible. And the first feedback was, this is way too in the weeds. You really, you really can't write this the way you would as a litigator. And it took a little while to understand that, but you're dealing with folks who are making important decisions every day on issues as wide-ranging as the budget to immigration to Supreme Court nominees and then patents in the mix as well.
What was the best piece of advice that you got, from people like Joe Mattal and others who kind of work on IP policy on Capitol Hill?
Sure. The best advice was just really developing a network of folks you can trust. And those could be, people I already knew. It could also be staff in other offices. It could be folks on the outside, either at various organizations or companies or lobbyists, some just independent, experts, people who are professors or otherwise who are in the field. And that was, for me, really essential, especially because most of my career I'd focused on patents, and I felt like I had a decent handle on that on the legal side. But copyrights, trade secrets, trademarks, I had encountered those from time to time in my career, but I didn't have the kind of expertise I would need to feel comfortable working with them.
And can you talk about that? Like, how did you develop a network of people you trust? Because obviously they're taking the time to talk to you. They probably have an agenda, or, that's why they're probably focusing on these issues in the first place. How do you navigate that? And how did you figure out who you can trust and who uses that opportunity to push their agenda?
Right. I guess there's a certain amount of trial and error involved for everyone. I had the great fortune of knowing a lot of people already that I trust in these fields and working from that. And also, Jamie Simpson was a tremendous resource, having been in exactly the same role for a few years before I got there. But it became apparent, that a lot of people come to the Hill to lobby for various things. And some folks, everyone has an agenda, especially folks who are being paid. But I could tell where things would just match up, and some people were more, well, I should say some people did a really good job of trying to lay the playing field out before advocating for the position and saying, look, there are some people who are going to feel very differently about this, and here's what you're going to hear from them. And here's my client's perspective or my perspective. And then there are also folks who don't necessarily have a specific stake, but like I said, some people who have just been involved in the policy world out of personal interest, or you have some academics and things like that, who also can be really great resources.
You joined Senator Coons at the time the Senate Subcommittee on IP was restarted. Did he kind of tell you, this is the reason why we're starting this subcommittee on IP, this is what I want to focus on? Did he set any kind of goals for the next 2 years? How did that kind of all come about?
So it was reconstituted a little bit before I got there. I got there in early 2019. What I can tell you is he was thrilled that it was back, and he was especially excited to be the ranking member. And he had a great working relationship, still does, as far as I know, with Senator Tillis, who was chair at the time. And honestly, it was almost kid in the candy store. Like, there's so much I'd love to do in this space, is I think what his perspective was. And this gave the bandwidth to have hearings and really dedicate some time and attention. The thing that was top of mind for the office when I got there was Section 101, patent eligibility reform.
During that time, you were, and we'll obviously talk a little bit more about Section 101, but during that time you were working for Senator Coons. Were you hearing from other Democratic senators on the subcommittee about what you should be focusing on, or how does that work? It's obviously Senator Coons is in that position, but I'm sure there's, or maybe that's the question, were there other Democratic senators even, spending their time kind of saying, this is what you should be focusing on versus you shouldn't be wasting your time with 101? Did you get that kind of feedback, or is it kind of siloed?
So I wouldn't say anyone said you're wasting your time. I think there are varying levels of interest that just go back to bandwidth. There's so much to be handled, even within the Judiciary Committee. But we had a lot of active involvement from other folks on the committee, and I wouldn't even separate it out so much on the Democratic versus Republican side for IP. Most of these issues are bipartisan. And they're very controversial, as you know, whether it's copyright, whether it's patent, and you have people coming with very different views. But I worked with as many Republican offices and staff as I did the Democrats, and which was great. And some, a couple examples that maybe on the Dem side, we worked very closely with Senator Hirono's office on several projects. And I know like one example would be the IDEA Act, which relates to diversity. And we were glad to help push that forward. That was a real passion of hers. And on the Republican side, we worked with a lot of folks, and most closely with Senator Tillis's office. I worked very closely with Brad Watts, who I know you've had on the podcast before, great friend, also just very passionate about IP. And so it's nice to have a less partisan forum to debate policy.
Yes, especially during those 2 years, I'm sure it was refreshing for some of those senators as well. Did Senator Leahy, who's obviously been interested in IP issues for a long time, did he have input into what the subcommittee was doing while you were there?
So we did work with his office some on, I recall, some copyright issues. And we certainly were open to input from anyone in terms of topics. My recollection is that, our office, the Senator Coons office, I should say, and Senator Tillis's office, we worked very closely together in terms of selecting hearings and that sort of thing. But certainly when we were talking about bills, introducing bills, moving bills forward, we were working with all the other folks on the committee.
Main focus of the subcommittee while you were there, and I don't know if you'd agree or disagree with that. Can you tell us, did Senator Coons, did he envision about how this would play out? Did he have like a dream scenario? Did he think it was realistic to actually get it done within those 2 years?
Right. Well, I hesitate to speak for him in terms of ultimately what he anticipated. I know that he was very clear-eyed about the challenge. We knew this was not going to be easy. We knew that the odds were stacked against it. But I think it's fair to say that we were hopeful that we could make some progress. And for a little while, it looked like we were making progress. You mentioned this being the focus. I would say this was the focus of the first year of my 2.5 years, roughly, with Senator Coons. And that's because the effort did, unfortunately, fall apart towards the end of that first year. But we really were trying to do something that could be a consensus, or at least as close to a consensus solution as possible. And we tried to solicit input from all corners, and we never actually introduced a bill. We did have a draft bill that was the basis for the hearings that we held in 2019. And it wasn't, at least as from the perspective of all of us involved, and by that I mean, there were various members on both sides of the Hill, lots of staff, so many meetings and discussions, and I really enjoyed it. The philosopher part of me, how do we rethink this system? But we really were aiming for something that would be viable and that would address the concerns on all sides. And it was very disappointing to see that fall apart. And I know I can say that Senator Coons was very disappointed that the effort was not able to move forward.
Yeah. So that draft bill that you mentioned for Section 101 reform, it had two parts to it. One is the kind of making patent eligibility more clear. That's the Section 101 part. And then it had changes to Section 112, which I guess some in the pro-patent community didn't like those changes. How did the idea come about to marry those two things together? How did that idea come about?
The draft text was certainly an evolution that had a lot of input from a lot of people. What I can tell you is that the idea of 112 being involved was part of the discussion as soon as I got to the Hill. And certainly exactly how that would manifest itself was unclear. I know something we had discussed at roundtables that we held before we had the hearings and before we released the draft text. What I can tell you is, for me personally, this is my personal perspective, is Section 101 evolved in kind of an interesting way because 112 hadn't been enforced, I think, evenly across all technology areas, and hadn't always been a priority for enforcement at the USPTO. And this is not me as a former PTO employee. This is just someone who's loves patent law and looking back historically through examiner guidance. And people have, at the end of the day, those folks who are concerned about what they would view as patents with 101 problems. Often when they start describing the patents to me, it sounds more like a 112 problem, where there's a disconnect between the claims and the specification, or maybe things aren't fully described. Maybe through a series of continuations, the claims have evolved into something that's somewhat different than what was originally described. And so what we were trying to do at the end of the day, I know from certainly for all of us who were really trying to find a solution, was address those concerns, but do it in a way that made more sense. Because as you know, there's so much controversy about what is an abstract idea? What does it mean to be directed to the abstract idea? How do we grapple with these concepts that sound a lot like obviousness, but it's not obviousness, and you don't have all the same framework and protections that you would have in a 103 analysis. So we thought, can we just make 101 clear? And to the extent you have concerns about, for lack of a better term, abstractness, maybe we could shift that somewhere else, and 112 seemed like the logical place.
And you mentioned I think you had 3 days of hearings. I think it was 45 witnesses. It was in some ways an unprecedented demonstration that I saw, trying to bring all the different voices in. And from what I read, there was a 3-page draft bill that was being privately shared. Why didn't another version of the bill ever get released? And why do you think the effort ultimately failed?
Yeah. So, well, just to clarify, the draft bill for the hearings was public.
Okay.
And it's still out there. There was never another draft per se. What we did do is we continued to meet with stakeholders on all sides of this and float various ideas. What you have concerns. What if we tweak this? What if we rethought this part of the framework? What if we added some additional provisions, some safeguards against other types of concerns? But ultimately, the reason it fell apart was we couldn't get critical mass on what I'll call the pro-reform side. So obviously there are some folks who are happy with the state of the law now, and some pretty significant players in terms of influence, and the system's working for them. So I understand the perspective, and that came out at the hearings. So you had a lot of folks who said, let's just leave it alone. We don't even want to hear what you're thinking about doing because we love the system the way it is. And that wasn't everyone. We had a lot of folks who really did engage, who said, we love the state of the law, but here's how we would do it. That was great. That was very much appreciated. But because there was so much opposition, what the members really needed was, if not a totally unified front, at least a significant number of folks who were fully on board and were really enthusiastic about whatever the fix might be, and were willing to help explain and advocate for that fix. And there was just so much disagreement, certainly on the 112 point. There was a lot of disagreement about whether that made sense, whether that would do more harm than good from a patent owner perspective, but there was also disagreement just about the framework itself. The current law really is a set of exceptions, and what we did with the initial draft was we turned that around into a more of a positive definition of what would be eligible. And people have very different views about that. And it got to the point where I think people started digging in even more the more we talked about it, to where we had a few different options for what we could do in terms of, we could have introduced something, but we had massive opposition to any change. And then we had roughly half of the, like I said, pro-reform community that said they couldn't support what we were going to do if we went one way or the other. And that's when we realized this just wasn't really going to go anywhere in the short term. That keep having talks, but we had devoted so much bandwidth to this, and there were so many other things that merited attention as well, that once we saw the deadlock was pretty serious, we moved on, and we actually did a lot of work in copyright law during the second half of my time there.
So that's very interesting. Listening to that, it seems like a huge missed opportunity, right? Because you have Senator Tillis, Senator Coons, who are devoting a huge amount of effort and time to this. They want to make this change to Section 101 to make clear, and then the groups that support these efforts, they refuse to kind of work with you. Is my understanding correct? They refuse to kind of work with you to reach consensus. Was that kind of your sense?
I mean, that's pretty strong. I don't know that I would say that. I would say people, by and large, were great about working with us and discussing potential avenues for reform. A lot of the disagreements weren't so much, well, certainly they disagree with some things we propose, but a disagreement amongst the stakeholders. And we would see this talking with folks privately. We'd see this with folks, whether it was a roundtable situation or, even just at conferences and things like that, I'd see the same discussion play out. And so there was, I think a couple of things. One, being willing to be flexible in terms of the approach. And everyone seems to have a different perspective on the best way to fix 101. I have my thoughts. I'm sure you have thoughts. Everyone has a slightly different view, but willing to be flexible if you really want to see the law clarified. And if you're someone like Senator Coons, where it's not just clarifying some of the murky areas, but also restoring eligibility for things like medical diagnostic methods that are almost completely foreclosed right now from protection. There needs to be some flexibility. And then also just being realistic about the opposition and the fact that there's probably going to have to be compromise with the folks who don't want to change the law. And not everyone was prepared to do that.
What's a lesson to be learned for the future from that, for those still who want some legislative effort to change Section 101, and what does realistically have to happen?
Well, so I know a lot continues to happen among the folks who really care about this issue. I know there have been ongoing discussions in various groups of stakeholders who continue to really, dedicate a lot of bandwidth to figuring out what a viable solution might look like and working with each other to try to iron out differences. I think that's really important. I think that's part of what has to happen. And I know some people have also made efforts to educate policymakers on the Hill about Section 101, why they think it needs to be reformed. And I think that's really critical as well. Every time, whenever this does come up again formally, which I hope it does, if staff, senators, members of the House are going to hear from the same stakeholders who came to us a couple years ago, who say, don't touch this law. If you do this, you're going to destroy America, essentially, whatever the case may be. Like, the internet will cease to exist, drug prices will skyrocket, etc. And So the other thing I think that's challenging is the pendulum has swung, I think, back and forth through my career in terms of whether the law is more favorable for a party on one side versus the other of the V, at least in litigation. But there has been such an effective campaign around the patent troll idea, and I should just say I've been on all sides of this. When I was in Oregon, I worked for the firm Clarquist, and I did mostly defense work. I've done plaintiff work and defense work at Kirkland. I'm doing some plaintiff work now as well as some policy work at IREL. But it was amazing to me for the first time ever as a patent professional, I don't know, maybe 10 years ago, to be in an airport and see a billboard talking about patents, and it was about patent trolls. And John Oliver did a segment about it on his show just many years back. And I understand the concerns that drove some of that, but it was interesting to me on the Hill when I would bring up patents to someone, staffer who didn't have any particular IP expertise, and the first thing I'd hear would be, "Oh, is this about the trolls or the thickets?" And that's what they knew. Like these catchphrases were effective, and so the narrative of patents as a driver of innovation, I think, could use a PR campaign, frankly.
That's good advice. This kind of related to that. I mean, one of the other efforts, at least from my vantage points while you were there by Senator Coons, was to kind of keep pushing the stronger patent acts or the strong patent acts. I know it's taken a few different acronyms. What was the goal there? Because obviously Senator Tillis was not a co-sponsor of that. Was that kind of a long-term play? Can you guys give us a sense of?
So, I mean, first of all, I should say, obviously I'm not there now, and I'm not speaking for the office. I know that what started out as the Strong Patents Act and became the Stronger Patents Act was very important to Senator Coons. He has many concerns about the way the PTAB trials have evolved, the way they were implemented from the American Invents Act, and also about some of the challenges facing patent holders, especially smaller startups, individual inventors, entrepreneurs, and that the playing field really isn't level. And so obviously Stronger, for anyone familiar with it, deals with some PTAB reforms, but also would make a significant change to the law regarding injunctive relief. It would establish some presumptions on 2 of the 4 eBay factors. And I know he continues to view that all those issues as very important. I should mention fee shifting as well, which is near and dear to his heart. So yeah, we didn't have Senator Tillis on board. I know there was agreement on some, but not all of those issues. We did have several folks from both sides of the aisle and both sides of the Hill who were co-sponsors. And it would be great to see that out there again. But really, my understanding is that the bill, way before I got there, was introduced when a lot of other legislation was being introduced as well, kind of the follow-on bills to the AIA. And this took a very different approach. And I think for Senator Coons, has served as somewhat, a line in the sand for where he views patent policy needs to go.
Yeah, and as I was preparing for the interview today, I saw Senator Durbin, Cotton, Hirono, Kennedy, and Kramer are all co-sponsors. So that's it seems like it's growing. Do you feel like the momentum was growing for a stronger patent act to become reality?
So, I mean, I don't think I'm giving anything away when I say it would be very challenging, I think, to pass any law that's making these types of or changes of this magnitude to the patent law, because you have such established interests with very different from very different perspectives, just because the patent system is impacting them very differently. And of course, now the playing field's a little bit different because Chairman Leahy has introduced a bill with Senator Cotton that goes a very different direction, I think it's fair to say, when it comes to the PTAB. I do think we had some momentum in terms of just moving the bill forward while I was there. We were really glad to have a hearing in the IP subcommittee.
So Leahy was Senator Coordinate, right?
Oh, I'm sorry.
Yeah.
I misspoke.
I just want to make sure to give Senator Cotton his pro-patent views credit.
And many apologies.
No.
And I should say, speaking of Senator Cornyn, we work with them on some IP bills with that office as well. And that was very enjoyable. I know, I would not expect to see Senator Coons as a co-sponsor of the Restoring the AIA Act. But I think it is just very challenging. And one thing that I didn't understand before I got to the Hill was just how easy it is to stop something from happening. It's very hard to get something done. And that's probably by design, maybe for the best in the big picture. But the story I always tell folks is, while I was there, the CASE Act was pending, which is a copyright bill, small claims tribunal in the Copyright Office. Seems like a great idea to me. There were folks who had some concerns, but notwithstanding those concerns, it passed overwhelmingly in the House, bipartisan basis. It passed through the Judiciary Committee unanimously in the same Congress where we had, 2 impeachment trials and everything else. And essentially, one senator who did have some concerns was able to hold that bill up. And it eventually got done. It is law now. It went through as part of a package with several other bills, and I was glad to be involved in that effort. But it was very clear that if someone opposes and you can't get to 100 senators, then you're going to have floor time and have a debate. And there are a lot of other issues, pressing for that floor time.
No, that's a good lesson. And I think obviously the people pushing against the Section 101 reform efforts kind of seem to know that as well, that there's a lot of opportunities to stop legislation. You mentioned, obviously Senator Leahy, he took over as chair of the Senate IP subcommittee. He's obviously, also the chair of Appropriations Committee, which is one of the most powerful committees in the Senate. He's the second oldest member of a Democratic caucus. Were you surprised that he decided to take the chairmanship from Senator Coons, who's obviously, as you've repeatedly mentioned, very personally interested in these issues?
Well, I don't think it's a surprise that Senator Leahy cares deeply about IP. He's been involved with that for many years. And obviously the AIA, which we've been discussing, it's the Leahy-Smith America Invents Act. And so it's not surprising that he would want to be involved. Probably not privy to all the things that happen in terms of committee and subcommittee assignments. It was assigned to him. I'd hesitate to characterize it as taking it away from Senator Coons. I know that Senator Coons would have really enjoyed the opportunity to chair the subcommittee. He cares about these issues so deeply. He is chairing a different subcommittee dealing with technology, and I was fortunate enough to be there for the first hearing, which was fascinating. Not IP, but talking about the algorithms of social media, and we won't go down that rabbit hole. But it's really interesting stuff, which I know he also cares about deeply. But it is great to have the IP subcommittee there, which wasn't for so many years. And I know both Senator Leahy and Senator Tillis at bottom are people who really care about the intellectual property system and want to do everything they can to strengthen it. And just folks have very different perspectives about what that involves.
I noticed an interesting dynamic. Senator Tillis obviously worked very closely with Senator Coons on a lot of these patent issues. And now he seems very close and aligned with Senator Leahy on a lot of patent issues, even though, Leahy and Coons seem diametrically opposed on a lot of issues. I mean, how do you explain that? Is Senator Tillis just wants to find a bipartisan way to work on any patent issues he can, or is it just happens that he's able to find common ground with both senators?
I'd really hesitate to opine on that. Maybe you need Brad to come back. What I can tell you is we had a great working relationship. I know the senators did. As far as I know, still do. I really enjoyed working with that office and working with Brad. And we weren't always able to find common ground, but I will say that they were very good about working with us to try to find the common ground. What can we do? So maybe we can't agree on this thing, but is there something where we can make meaningful progress where we do agree? And even I'll just say with Senator Leahy, I know the perspective on patent law may be different on some points than Senator Coons, for example, but certainly there were issues of copyright law, for example, where I personally work with that office. I know the senators have worked together where there is a lot of common ground. And I would suspect there's common ground even within the patent realm. And I also think that at the end of the day, it's really good for the staff to have hopefully the same types of conversations I had during my time there, where even if we disagreed, we tried to talk through it, because sometimes folks are just hearing from different perspectives. You could have different, whether it's lobbyists or professors, whoever else, coming in and giving one view of the world, and maybe you see it from a slightly different perspective, and that's when you could start having a conversation and start figuring out a path forward.
Obviously, you mentioned Senator Leahy. Now he introduced a new act to kind of strengthen his vision of AIA, but he announced he's going to be retiring in 2 years. How are you thinking about what will happen on Capitol Hill, I guess, after he retires? How's the debate going to play out on these issues in terms of that? I'm thinking of post-grant proceedings mostly, but also on other patent issues once he retires.
I mean, that's a great question. Well, first of all, it'd be a question of whether there even is an IP subcommittee in the Senate. And if there is, who will be leading that? And I certainly don't have the expertise to make those kinds of predictions. I would say I hope that all of these debates remain a significant part of what's going on the Hill and a part of the discussion, because whether it's patents, trade secrets, trademarks, copyright, my sense is there are a lot of issues that really merit attention, where there is room for compromise and for making real improvements to the system. And I would hope that continues to happen, and hope to still have a foot in that world.
There was lots of hope that Senator Coons, who's I think there's a lot been written about him being a close friend of President Joe Biden, being able to push the Biden administration in a pro-patent direction. But, on almost every major policy issue, and I'm thinking about the COVID-19 IP waiver, the new draft standard essential patent policy, the Biden administration seems to have taken the less patent-friendly positions on those. Why do you think it has played out in that way? What do you think is driving those decisions?
Yeah, so I mean, I definitely can't, don't want to speak for the administration or kind of speculate about what might be driving various policy positions. I would say that, from my perspective, you're absolutely right that when it comes to intellectual property, the Biden administration seems to have taken a very different path than the one that someone like Senator Coons might have chosen. And it's interesting. I think what's most interesting to me about it is that some of the voices that are the strongest on the side of, I'm not going to say weakening patents, but on concerns about whether it's characterized as low quality patents or patent trolls or litigation abuse, are some of the very large tech companies. And again, I understand where that perspective is coming from. What's interesting, though, is those companies are very much in the crosshairs right now on other issues like antitrust. And whether it's on the Hill or in the administration, frankly, they're fighting on a lot of fronts. But when it comes to intellectual property, it seems like they've actually made some significant inroads in terms of policy, certainly patent policy. And I think that's just an interesting state of affairs. I'll leave it at that.
You made an interesting point before about how the divide on these issues isn't really partisan. You have different members of Democrats and Republicans who fall on different parts of these issues. Does it make a difference what specific senators or congressmen support what? Or do you think it might, in some ways, kind of hurt the cause, the fact that Congressman A is associated with this issue versus Congressman B?
So, look, I certainly don't want to characterize any of the members of Congress as, in terms of their effectiveness or somehow being a poison pill for any policy effort. One thing that always impressed me about Senator Coons during my time there was his willingness to be practical and find ways to work with folks with whom he disagreed. But I will say that, there are politics involved on the Hill, and certainly during my time there, I would be surprised by things that were not necessarily that I didn't personally anticipate as being challenges. And they weren't always necessarily politics in the way we think of it in the news, but relationships. You have members who are at any given time in the midst of negotiating so many things, hundreds of different issues. And so the dynamics between these offices and between the members themselves is very complex. And so that can factor in. And I didn't always have visibility into that until until someone told me, and then I realized, oh, this is going to be much harder than I thought it was. So I think that's all. And they're also just the other thing that was interesting to me, that a little different than what you're asking about, was just the interplay between the IP issues and all of the other policy issues that these folks are responsible for. And for me as a detailee, it was just a great opportunity to learn more about, whether it was public health policy or national security or international trade, all of these issues that where there's interplay with intellectual property, and having really interesting conversations with folks on and off the Hill who said, I understand this is why your perspective, why you might have this view as a patent litigator, but let me give you this view from a completely different perspective. And it really opened my eyes, and I think it's part of what makes the Hill a really interesting place.
So I think the dynamic you're describing is that two offices or two senators who are disagreeing about other issues, it might be harder to work with them on IP issues. At the same time, if another senator is issued, let's say he's interested in defense policy or 5G or something like that, that might make it easier to work with him on patent issues, right? If that's the kind of interplay you're describing.
I think that is possible. I think there's also a certain amount of horse trading that goes on, right? On the Hill. And there certainly are situations where people are looking to get things done. They want to cut deals. And you could have situations where you're not debating one bill in isolation. Maybe you're reaching out to someone else's office and they've been trying for months to get your boss to sign up for a bill that has nothing to do with intellectual property. And then maybe that involves getting more people in a room and hashing it out. So yeah, it's a complicated place. It could be a little bit confusing, a little bit overwhelming. It was for me when I got there. But the amazing thing is that despite all the challenges of getting things done, occasionally they do get done, and sometimes they get done really quickly. I was worried at one point that we weren't going to have any IP bills enacted into law during my time on the Hill, and then towards the end of last year, all of a sudden, boom, we had 3 of them that got done, which was great. But it could be very unpredictable in that way.
Wanted to get your advice obviously you have a very interesting background on Capitol Hill and before that, but now you're back in private practice, where I think you mentioned you're focusing on patent litigation, but you're also giving public policy advice. A lot of times, companies or patent owners don't start thinking about, or not just patent owners, I guess on both sides, they don't start thinking about patent policy until they're involved in patent litigation or enforcement efforts. What advice would you give about when should they start thinking about it and how should they think about patent policy issues?
So I think it's really important if you're in an industry where intellectual property rights have a material impact on your business, which is frankly a lot of folks, especially here in the United States. The challenge, as you mentioned, is especially for smaller companies, having the bandwidth to focus on something like policy and potential changes in the law is really tricky. And that is a real challenge because it's some of those same folks who can be impacted the most drastically by an adverse change in the law or an adverse decision in the courts when it comes to something like a copyright or a patent. So I would encourage folks who are involved with, in-house for companies to think about ways to collaborate with other similarly situated individuals, organizations, companies, because there is, a lot of work sharing that could be done, and people can be very effective in coalitions. And I know certainly I saw that while I was on the Hill and spoke with folks from coalitions with very different perspectives. But having a voice in the debate, I think, is important. There are, potentially some very big shifts in the law. We talked a lot about Section 101. If Section 101 is reformed, it could have an enormous impact, particularly on industries where patent protection may be available where it was not before, or vice versa. And at the end of the day, I really enjoy that process, and that's why I should say I'm really happy to have found a place where I could still do some work in the policy space, but also get back to my litigation roots. So where some of my job is talking with folks about patent policy, either about their own policy agendas, potential legislation or advice about legislation that's being considered, or also policy that happens at the agency level. And a lot of interesting policy debates at the USPTO, for example, and some of the other agencies. And so it's been a real pleasure to not only get back to doing actual litigation work, but also to doing some of this policy work on the private side. And of course, had the opportunity to work with the former PTO director, Yanku, which has also been great, has just a tremendous perspective, having led the agency for several years.
And you've given a lot of good practical advice about how to be effective. Trying to influence what's happening with regards to patent policy. One is, you want to be somebody who's trustworthy, which I think kind of makes sense. It's good to form coalitions and groups with like-minded entities that you can kind of align and communicate together. But I think, you talked about it before, and you said you've had experience with lobbying efforts that were not effective. Can you give us some sense of what you think kind of doesn't work in terms of trying to influence patent policy?
Sure. Well, maybe I flip it around first and tell you, I think what does work is someone, first of all, you have to know the facts. You have to understand the playing field. So you could come in and give a realistic, honest sense of, A, what is the issue, and B, where do folks stand on it? Because I know that was always one of the first questions. I'd go to someone else in the Senator Coons office and say, here's this great idea, and so has a solution. I'm like, okay, great. Like, who opposes it? Because you want to know, like, what are the challenges? Like, what are the hurdles, and how can we, deal with those? So coming in with, a clear explanation of what the problem is, especially in terms that folks who don't spend their lives working in IP will understand, explaining who it hurts, why it is that way, who opposes, why they oppose, and importantly, obviously, like what the response is to those concerns. And then also having a proposed solution is critical. And that may sound obvious, but I certainly talked with a lot of individuals, organizations who said, we're very worried about this issue and it's adversely affecting us, and it would be great if you could spend some time figuring out how to fix it. And sometimes I and others and the senator may have been sympathetic to the position, but there is limited bandwidth. There are so many issues. Your odds of moving something forward go up immensely by bringing a specific solution and offering to assist with that. I think that's also very important, to the extent people have the time to do it, to say, here's the solution, here's the problem, here's why I think the roadblocks are going to be, here's how we think we might be able to overcome them, and importantly, here's what we or other people we've been discussing this with can help you with that. And maybe that involves going and talking to other staff, other offices. Maybe that involves educational efforts or writing op-eds, things like that.
Yeah, no, I think about the specific solution, I think that's maybe even a bit counterintuitive, because some might think, well, it's kind of heavy-handed for me to come there and say, this is a problem, this is exactly what I think should be done. But you're saying because of just from a realistic perspective, the bandwidth that Capitol Hill staffers and obviously senators themselves have, it might be necessary, right, to at least come with something that kind of shows a pathway to kind of solving the problem, right?
I think it helps. Now, the important caveat to that is, don't be wedded to that specific solution, because chances are whatever you've typed up will not become law. So there's that flexibility, but having a starting point. I always thought that was incredibly helpful, and I saw some folks who did that. And I certainly saw some things where, certainly if you're not trustworthy, that's a huge roadblock. But also if it was not clear that there was a path forward for the opposition. If someone would come in and say, here's this issue, and people are going to jump up and down to stop you if you try to put forward a solution, and I don't know what you do about that. Some bills still happen that way. There are bills that are markers where a member feels strongly enough they want to take a stand. But it's a tough sell to say, we really think you should introduce this bill, and as soon as you do, you're going to be attacked on all sides. And also, by the way, it's probably has very low probability of being passed. You're going to need a pretty good justification for that.
Yeah. No, all that's great advice. Does any group or any person kind of stand out to you with regards to their effectiveness while you were there?
I don't know. I want to get into talking about specific folks. I would say there are just a tremendous number of really intelligent, thoughtful, and effective folks in this space. And I was really impressed with that. And I would include folks on all sides of these issues. And the ones who, and I'm not going to name names of folks who weren't effective, certainly, but if you come in and you just say, your boss wants to do X, and X is horrible, and you can't do it, and we're going to oppose it. I didn't find that to be very effective. I think there were folks who found ways to still have a conversation. I think that was really important.
You kind of touched upon it that, your experiences with patent policies, mostly on Capitol Hill. Obviously, Director Iancu, he comes from working for a government agency. I mean, do you have any thoughts about the difference between trying to influence members of Congress or the Senate versus trying to influence what an administration does? Because there's so many more things at play, at least it seems, when you're trying to do the latter. But do you have any thoughts?
Yeah, I mean, it's very different. One of the huge differences is that when you come to an agency like the USPTO, you're coming to a group of people who have an enormous amount of expertise, who have dedicated their careers to this area of the law. And that can be a very good thing. It also means you need to be very prepared to get into the weeds at a very deep level. So it's just a different kind of advocacy. You also have, a mix of career and political folks at the agency. And that's such a contrast. On the Hill, again, I mentioned this earlier, a lot of people, you have a staffer perhaps who is told, you are going to be working on guns and abortion and copyrights. Or probably not quite that mix, but something like that. And maybe it's someone who's never had any exposure to intellectual property before. So there's this first step, this educational step that has to happen.
So the last question that I have for you is, somebody's been listening to this and they're like, wow, Phil Warrick had a very interesting career. He's done it all, worked for a senator, now works closely with a former director of the USPTO. What advice would you give to somebody who wants to become the next Phil Warrick?
Well, first of all, I'm not sure that I would necessarily advise anyone to be the next Phil Warrick. It's been an interesting career path. I think the thing I would say is I would recommend that everyone have an open mind about what the career path might look like. When I was in law school, I had this idea that my career would involve graduating, joining a law firm, preferably one that did really good patent litigation work, working there for a few decades, and then retiring. And that seemed just great to me. And that's been the opposite of what I did. I mean, I was at Kirkland in New York. I came back and clerked, worked for Kirkland, D.C., worked for a firm in Portland for 5 years, the PTO, loaned out to the Hill, now working with IRL. But it's been fantastic, and I wouldn't change any of it. But it all involved being willing to take some chances, being willing to try something new. And so I think that is the main advice I would give is look for interesting opportunities, be willing to take them, be open-minded.
Great advice. Thank you so much for doing this.
Thanks for having me. It's been a real pleasure.
Thank you for listening to Clause 8. If you enjoyed this episode, please share it with others and leave a 5-star rating. I'd also like to thank my firm, Harity & Harity LLP, for their generous support. Clause 8 is produced by Great Feeling Studios and Brick Brewer. For more information, visit voiceofip.com. Thanks for listening.